Hello, and welcome to another episode of Law and Sarasota. I'm your host, Adam Tabrouge. Today, I'm joined by an outstanding attorney and member of the Sarasota County Bar Association, Deborah Salisbury. Deborah, welcome to the program.
Thank you so much for having me on the program today.
Deborah, I always like to talk with my guests about what it was that motivated them to go into the practice of law. What's your story? What was your journey to the legal field?
Well, Adam, I started out being a psychiatric nurse and actually became a psychiatric nurse practitioner. And I had done that for 12 to 14 years by the time I graduated and became a lawyer. And I just always liked helping people and working with people and trying to be a change agent. And I was looking for a different venue to help people change and help them resolve their problems. And I wound up in the law.
And where did you go to law school?
I went to Stetson in St. Petersburg and commuted every day.
How did you find that experience?
I thought Stetson was a wonderful trial school, and I learned so much there. And it was a small college, which I tend to like better than some of the bigger universities, even though I've been to bigger universities.
When did you graduate? And give us a little rundown of your career as an attorney.
Well, I graduated in 1992 in December. And then I began working for a small firm with 3 lawyers and some associates in the firm. And within a couple of years, I was out on my own. I've had my own practice since then, which works really well for me because I've been raising a family. And it gives me a little bit of flexibility, but I also have a very, very busy practice.
Tell us a little bit about your practice and what kind of areas of the law you concentrate in.
Well, I practice dependency law, which we're here to talk about today, family law. I do some civil litigation and collection work, and I do some Social Security work too.
Well, Deborah, as you mentioned, we're here today to talk about dependency law and dependency court. So let's introduce our viewers to the concept, what is a dependency proceeding?
A dependency proceeding is a proceeding involving an accusation of child abuse or neglect against the parents of the child. It usually starts out with a shelter hearing that happens after the Department of Children and Families has done an investigation and determined that there's probable cause to remove a child from their parents. And, typically, a child protective investigator will simply knock on the door, maybe have some police officers with her, and say, we're here to talk to you and ask some questions. They might want to look around the home to see how adequate it is, and they may be they're typically investigating a child abuse call. So it's very important that people understand that although they do not have to cooperate with that, if they don't, I think that it's going to raise more questions.
Let's say that I'm at home with my child, there's this knock on the door, and the investigation is taking place. Can they actually take my child out of the home?
They actually can take your child out of the home. They usually don't do it on the first visit unless there's something very, very serious going on. But certainly we have cases, unfortunately, in Sarasota County where parents are addicted to drugs. We've had cases where they have knocked on the door and the parent can't wake up to answer the door. We've had cases where children who are very young are found wandering around outside unsupervised when they're too young to be alone. In those types of cases, they probably would do something much more drastic and remove right then. But usually, they will go back to their office. They will investigate other collateral contacts, and then make a decision with an attorney at Child Legal Services as to whether or not to go back and remove the child.
Does a judge have to sign off on the removal of a child from the home?
No, judge does not.
If the Department of Children and Families makes this determination that they're going to remove the child, where does the child go?
Well, typically they're going to take the child back to their office while they're processing paperwork and trying to find a foster home or a family member for the child. Our Department of Children and Families here in Sarasota County and Manatee County and DeSoto County have made great strides to try to place children with families first. And that's what they're required to do under the statute. So if someone has their child removed, it's always in the child's best interest to give the name, telephone number, and address of a potential relative placement that could take the child and make the child more comfortable in a home that they're familiar with.
Now, you mentioned the word shelter. What were you referring to when you used that word?
The word shelter really means to remove the child from the parents and to bring them under protective supervision.
If my child is removed from the home, when might we see a judge to look into the situation?
Well, they're required to have a hearing right away, and frequently if that occurs on a weekend, they will have a hearing the next day before the on-call judge who may be handling the criminal arraignments and whatnot. So the parents may not really have that great of an opportunity to appear, but they always do a shelter review later that week with the dependency judge, the judge who hears these cases. And at that time, the parents should definitely make sure they're there. They should fill out a financial affidavit that the clerk of the court will provide to them and see if they qualify for court-appointed counsel. If they're indigent and they meet the guidelines that the clerk of the court is required to evaluate them by, they will be court-appointed a lawyer right then and there to help them with their case.
What other responsibilities does a judge have at these shelter review hearings?
Well, at the shelter review hearing, or at the original shelter hearing, the judge has to see if there really was probable cause for the state of Florida to step in and remove that child. If there was not, he is in all likelihood going to return the child, maybe with some special instructions to the parents. Most cases, however, the judge does grant the removal and allows the state to remove the child and then goes forward with the case. But not all. Some of them are called non-removal cases where they are ordered to comply with other particular services in the home to help the child be safe.
If I'm a parent, my child has been removed, I've gone to the shelter review hearing, and the judge rules that he's going to keep the child in shelter for the time being, what are some of the next steps that I'd be faced with?
Well, if you were my client, I would tell you that you are entitled to a visit with your child within 72 hours of removal. The only time that would not happen is if you unfortunately were accused of some type of inappropriate sexual conduct with a child. They have special protections under the statute where the visit would not be allowed then. Or in a situation where, unfortunately, if a parent has done something so severe to the child that the child's been traumatized, the judge may order that there be no contact. But otherwise, you would be entitled to see that child within 72 hours.
So I've had my visit with the child, and I want to do whatever it takes to reunite my family. What are some of the things that I should be thinking about or doing at this stage?
Well, I think some of the most important things are, number one, you don't want your child in foster care unless your child has to be in foster care. And it's not because the foster care folks aren't nice or the homes aren't well enough. It's just that children do better when they're with family members that they know. So the very first thing we're going to do is tell you, give us the name, address, and telephone number of anybody in your family that can take the child in and take care of the child. Those individuals would have to submit to some background screening and a home study before the department's going to say, okay, you can take little Johnny and take care of him. So that would be number one. Number two, depending on what your problems are, why the child was removed, I would tell you to consider starting services right away. Now, some folks don't want to do that because they say, I didn't do that, I want to go to trial, and then you may not want to start services. But the burden of proof in that courtroom, what the state has to prove to win on a dependency petition, is a preponderance of the evidence, which means for all of the rest of us that don't know the legal terms, 51% of the evidence. So it's a very low burden of proof that they have to prove in order to find that you neglected or abused the child and that the child is dependent.
You just mentioned services. What were you referring to when you used that term?
Well, so often today, unfortunately, kids are removed when their parents have substance abuse problems. So one of the first things the state is usually asking is for you to participate, or for the parent to participate in going to a substance abuse evaluation or screening. And then they're hopeful that the parent will cooperate and follow all recommendations if they want to have their children returned to them. So that would be one of the services that may be offered. Other services may be anger management screening, domestic violence screening to see if you've been involved in arguments at home, hitting, the significant other in front of the children, that type of thing. Parenting classes are another thing that is often a service that is often offered to parents. It's those types of services that they're looking to put in place so that you can overcome whatever problems you might have and that the child can be safely returned to you.
Deborah, as an attorney who represents parents who find themselves in this situation, what are some of the things that the attorney does in the initial stages of a dependency case?
Well, one of the things that we're going to do initially is if we happen to be appointed on the day of the shelter review hearing, we are going to be there to ask questions of the child protective investigator that removed the child to make sure that everything was done properly and that there are no other services that could be put in place for the child to be safely returned home right then and there. After that, we're going to start to enter a denial for you unless you want to consent, and we're going to start to ask for discovery. And that means all the paperwork and the documents that the state has from their investigation. It may also include tapes. Sometimes we get tapes of a parent talking to another parent who's incarcerated, things like that. It may be a taped interview of the child that we're going to get.
Well, Deborah, thank you so much for this information. And when we return, we're going to talk about the further progress of a dependency proceeding and the work that the attorneys do who are representing parents in this situation. So please stay with us for some more Law and Sarasota. We'll be right back.
The average text takes your eyes off the road for nearly 5 seconds.
In 1977, in Johannesburg, South Africa, an 8-year-old boy picked up the game of golf from his father. By the age of 9, he was already outplaying him. The odds of this gentle lad winning the Junior World Golf Championships at the age of 14, 1 in 16 million. The odds of that same boy then making it to the US and European Pro Golf Tours, 1 in 7 million. The odds of the Big Easy winning the Open Championship once and the US Open Championship twice, 1 in 780 million. The odds of this professional golfer having a child diagnosed with autism? 1 in 88. Ernie Els encourages you to learn more at autismspeaks.org/signs. Early diagnosis can make a lifetime of difference.
Welcome back to Law and Sarasota. I'm your host, Adam Tabrouge, and today I'm with Deborah Salisbury, and we're talking about dependency proceedings. Deborah, when we left off, you were talking about the work that the attorney does with the parents. There's another player in the court system called the guardian ad litem. Tell us just a little bit about their role in these cases.
Well, the guardian ad litem is typically a volunteer with the court system. There are some of them that are paid staff members, but there are a lot of volunteers. And they're usually people who are retired, not always though, that come wanting to help children in the community. And their job is to represent the best interests of the child, not to be confused with necessarily what the child wants, what they believe is in the best interests of the child. So they become a party to the action, and they actually participate in all court proceedings.
And who do they report to?
They report to the guardian ad litem attorney. They have attorneys that represent them in court, and their attorneys are in court with them at every single hearing.
Now, Deborah, the last court proceeding that we talked about was the shelter review. I now would like to ask you about a dependency petition.
Right.
What is that?
Well, shortly after we get through the shelter hearing, the parents will be served with a dependency petition that basically kind of reiterates the same allegations that caused the removal of the child. And they will have an opportunity to go to trial on that petition. But as I mentioned earlier, the burden of proof for the state to prove their case is 51% or better. So it's not hard for them to win their case if they have enough evidence. And frequently parents choose to just consent and work the case plan to be reunified with their children.
If a parent consents, what do you mean by a case plan? Where does that come from, and what are some of the things that we might find in a case plan?
Well, regardless of whether they consent or go to trial and lose, they're going to have a case plan that they need to work. And those are the services that we talked about earlier. And the case plan tends to be like a 20-page document that lays out each and every place that the parent is supposed to go to get these services and what is expected of them, such as that if they have to submit to random urine drug screens, or they have to attend NAAA meetings, or they have to complete the parenting classes and demonstrate that they actually benefited from them. So there's quite a few tasks that they have to get through, and often these parents don't have great financial resources. So the Department of Children and Families, through their subcontractors, pay for those services.
We've mentioned the possibility of a trial on the dependency petition. If there was a trial, what decision is it that the judge is being asked to make? Or put another way, what's the position of the state that they have to prove in the court?
The state is asking for the judge to find that the child or the children are abused or neglected, and that they can't safely be returned to the parents at that time. They're asking for the court to make a finding that the children are dependent children.
So if the court makes that finding, what next?
Well, the parent then has up to a year to substantially comply with the case plan, and that means that they have to have completed almost everything on the case plan. I sometimes see folks that decide, well, I'll do the parenting class, but I'm not ready to have a substance abuse evaluation done yet. Well, that's not the best decision to make, because clearly if your children were taken away because you have a substance abuse problem, you really need to work on that big problem first and get moving on it, because such problems take a long time to get resolved. So it's those types of issues. It may be housing, that they have to have adequate housing, they have to have income. So usually there's a lot of tasks that they have to be working on, and it's tough. It's tough for them to complete them, but not impossible. If they want their children back, they have to substantially comply within 1 year.
Who monitors the compliance of the parents with the case plan?
The case plan worker is the person that would monitor that. And in Sarasota County and Manatee County, we have subcontractors through the Department of Children and Families, known as the Safe Children Coalition. They have case managers available to assist the parents in working the case plan, to check on the child periodically, and to give a progress report to the court from time to time under the statute as to how everybody's doing on the case plan.
What are some of the consequences that could affect a parent if they fail to live up to their responsibilities under the case plan?
Well, there are a few different things that can happen. The court can choose to simply close the case and leave the child in a permanent guardianship with an adult relative or a non-relative. to be raised until the child turns 18. That is happening, I think, less and less than it used to, because more and more relatives are deciding that they wish to adopt the child. If that's what happens, the next thing the parent's going to be facing is a petition for termination of parental rights, which is like the third segment of a dependency proceeding. And the burden of proof there gets tougher for the state, because if they want to terminate somebody's parental rights and take away their ability to parent that child anymore, they have to prove by clear and convincing evidence that the parent should not be allowed to maintain their parental rights and that it's in the best interest of the child to terminate the parental rights. If the child happens to be of American Indian heritage and the parents meet certain criteria under the Indian Child Welfare Act, the burden of proof becomes even greater, and it becomes beyond a reasonable doubt, and they have to also have an Indian expert testify at that point. So it's more complex. And then it's serious business at that point. It's serious business when any child gets taken away, but I think too often parents wait, and they don't get serious enough on the case plan fast enough to get their child back right away. And waiting is a mistake, because after the year is up, the state cannot stay in that position. They have to either close the case in a permanent guardianship, or they have to find another placement for the child under other sections of the statute that aren't really relevant today, or they have to move to terminate parental rights.
We've talked about these different burdens of proof, but just so that we're clear, you don't have a right to a jury trial to decide whether or not you're going to lose your parental rights.
No, it's a bench trial with a judge, and that judge usually hears the whole case from the beginning to end. So it's very important for everybody to behave themselves in court and when they come into court, make sure that they know that they're not using drugs, because if there's a drug issue, in all likelihood, they're going to be asked to go over to drug court after they leave court and give a urine sample that day. And I always say to people, if you don't behave well in court, then the judge is going to remember that, and you don't want the judge to remember that when you go to trial.
What is a judge deciding at a termination of parental rights hearing? What's the issue at that point? I know you talked about that the state has to prove beyond a reasonable doubt abuse or neglect, but what are some of the other findings that a judge must make?
Well, they have to have certain findings that they're proceeding under. One of the ones that I kind of alluded to was a failed case plan, that they didn't pass their case plan tasks and they didn't complete them and substantially comply. But there are other ways that one can lose their child too. If they've been sentenced to prison for a long period of time when they're going to be away, they could lose their parental rights, because most courts now do not think it's appropriate with the new statutory changes for a parent to hang on to those parental rights if they're going to be in prison for the rest of the child's life. Obviously, they're not going to be able to parent. Now, I'm talking about if the child's very young. If the child's 16 and the parent goes to prison, it may be that the state decides not to terminate the parental rights because it's only 2 more years for the child to remain in the system. But there are other bases too, like egregious conduct to the child, where egregious conduct to another child that's a sibling of the child. So there are multiple different bases that they can seek a termination of parental rights under. And they also have to prove that it's in the best interest of the child to terminate parental rights, and that the child will not languish in foster care, and that the child is capable of forming significant bonds with their new caregivers. So there's many, many things that have to be proven. It's an uphill battle for the state, but if the parent hasn't done their case plan or does bad things to children, the state will get there.
Deborah, let's say again that I'm the parent and my child has been removed from the home. And we went through the shelter hearing, we went through the dependency petition. Can I appeal the judge's decision at the end of the dependency petition? Do I have to wait until my parental rights are terminated?
No, you can appeal the decision at the end of the dependency petition. However, I would advise you, if you're going to appeal, that perhaps you want to work your case plan in the meantime, because that clock is still going to be running for the 1 year.
Do I have to appeal at that time, Or do I have a right to appeal after my parental rights are terminated?
You have another right to appeal after your parental rights are terminated. However, many parents who realize that they cannot complete the case plan, or some parents, decide that they want to surrender the child for adoption, sometimes by a family member, sometimes by someone they know. It may be that the parent has actually met the foster parent and thinks that the child's in a good place, and they may choose to surrender. And then the standard is a little bit different to file an appeal. They have to really prove that they were, duressed into this coercion, and that's a very tough standard to prove.
Generally speaking, if a parent finds themselves in this position, their child has been removed from the home, what should be the number one course of action at that point?
Initially, if the child's removed, I would say that one thing you don't want to do is alienate the people that are removing the child. I've always known that if you get along with the people that are trying to provide services and offering you services and cooperate and try to do what's right, you're going to get a lot further in keeping that child. It just makes sense. Even if you get to the dependency phase of it, you have a case manager. If you want to buck the case manager all the way through, life's going to be a lot harder. You want to try to cooperate with these people and work with them. They're just trying to do their job.
Well, Deborah, I really appreciate you being on the program. I know that this is a difficult and emotional area of the law, but it's also an extremely important one. So thank you so much for coming on and allowing our viewers to understand these processes better.
Well, Adam, thank you so much for having me on today. I enjoyed it.
And thank you very much for watching another episode of Law and Sarasota.